preset the microphone for me. It's, hello, everyone. Look, I wanted to take a few minutes mostly to make myself available given the Supreme Court of Canada decision today. By now, I expect you will have heard that the Supreme Court of Canada has upheld the validity of the Safe Third Country Agreement between Canada and the United States. I'd like to point out that Canada is going to remain a world leader when it comes to the resettlement of some of the world's most vulnerable people. Just a few days ago, in fact, the UNHCR confirmed for the 4th year in a row that Canada has resettled more refugees than any other country in the world. It's important, if we're going to continue to have the ambition of being a world leader on refugee resettlement, that we promote regular migration pathways and orderly management at the border. And part of the path forward is going to include not just welcoming significant numbers of vulnerable people, but helping build capacity in parts of the world that struggle to keep up with the extraordinary demands that irregular migration is placing upon them. We've learned recently that there is approximately 110 million displaced people around the world. This challenge is not going away. We're going to be partnering with states in the region, including Central and South America, and also civil society organizations to help address irregular migration at the root. By addressing the root cause of violence, war, and persecution, and building capacity of states who deal with significant numbers of people who are in search of asylum, we'll be able to make a meaningful contribution to this global challenge. But in the meantime, we want to assure Canadians that we're going to continue to respect the domestic and international legal obligations we have to protect the rights of the vulnerable at the same time that we promote orderly migration. I'm happy to take a few moments to answer what questions you may have.
The refugee advocates who brought the challenge say that while the judge recognized that there are risks of detention and refoulement, that there are safety valves in the law, but they say they exist only on paper and they're not in practice there, and they want you to suspend the agreement right now anyway. Is that even a remote possibility?
We're not engaged in a conversation internally about suspending the agreement that we achieved with the United States through significant months, in fact years of work, immediately after the Supreme Court confirms its validity. The reality is the safety valves that you spoke of are a significant component of why the court upheld the validity of the Safe Third Country Agreement. It's important to understand that in addition to changing the posture at the border, that there are exemptions that exist. Exemptions that exist for people who have family members that are in Canada, for unaccompanied minors, and for other public policy reasons. The discretion of officers at the border to implement decisions, despite the fact a person may have crossed through the United States, is an important component that will allow people to continue to make a claim where the facts determine that they, in fact, were not safe in the United States. That discretionary ability for officers to manage things on a case-by-case basis as they arrive is an important component of it, despite the fact that the rule has now applied similar rules that exist at points of entry to the rest of the Canada-US border. So to answer your question directly, Tonda, no, we're not going to be suspending the agreement. We're going to be using the agreement to foster a culture of regular migration. At the same time, we continue to be a world leader when it comes to resettling some of the world's most vulnerable.
But now Amnesty International is saying that these safety valves are not efficient at the border, that migrants that are coming, they don't have access to a lawyer, for instance, and so it's not a real accessibility to them. What do you respond to them?
First of all, I have enormous respect for Amnesty as an organization, and I thank them for the advocacy work that they do in Canada and around the world. And the world is a better place for their contributions to discourse on protecting the world's vulnerable. I have a point of disagreement on this particular issue. The reality is that the court's decision recognizes that governments have the ability to cooperate with their neighbors when it comes to the management of their borders, including the protection of vulnerable people. It's important to understand that the United States also has an asylum system that allows people to make claims with the benefits of some of the protections that you've mentioned. There may be certain individual cases where the public interest demands a different approach is taken, and those safety valves can kick in those instances. But for the vast majority of people who come and present themselves to make an asylum claim that do not qualify for the exemptions, most of them will have the ability to make a similar claim under the system that exists in the United States. It doesn't mean that the two systems are identical to one another, but they do have a functioning asylum system. Part of my role as the Minister of Immigration is to routinely conduct reviews of our partners that we have such an agreement with, in this case the United States, to ensure that they meet that standard of being a safe third country. But ultimately, in rare cases, there will be an opportunity for an officer to use those safety valves, to use the court's language, to provide justice where the rules in a given set of circumstances wouldn't do so.
Can you try that in French on
Oui,
the
oui.
safety valves.
Je vais essayer en français et juste permettez-moi d'essayer, mais je m'excuse en avance si j'ai fait des erreurs. Mais aujourd'hui, le cours a reconnu l'habilité pour le gouvernement du Canada de continuer d'utiliser l'entente avec les États-Unis pour renforcer nos frontières et protéger les personnes qui sont plus vulnérables en même temps. Alors, c'est essentiel pour continuer d'accueillir des personnes qui sont plus vulnérables et avec des investissements dans la région, c'est possible pour construire les capacités dans la région et accueillir des personnes qui sont plus vulnérables en même temps. Avec des exceptions de l'entente, c'est possible pour des personnes avec leur famille au Canada, les enfants sans parents qui arrivent pour chercher d'asile au Canada. Mais c'est très important de reconnaître les décisions de la Cour fournir l'habilité de le gouvernement de continuer d'utiliser l'entente parce qu'il y a des opportunités pour des personnes qui cherchent d'asile quand la situation demande une réponse unique. Je ne sais pas les bons mots pour safety valve en français, mais ce facteur est très important dans la décision de la Cour aujourd'hui et c'est très important pour continuer d'utiliser des choses maintenant pour renforcer l'entente. C'est OK?
Oui, Amnesty International dit...
Plus long,
oui,
s'il vous plaît. Ouais.
Amnesty International dit que justement, le terme c'est soupape, mais disons ce droit discrétionnaire que le gouvernement a de ne pas renvoyer des gens qui seraient en danger aux États-Unis, vous ne l'exercez pas. Est-ce que les agents de services frontaliers sont au courant qu'ils peuvent exercer ce droit-là? Parce que ce que Amnesty dit, c'est qu'il y a un risque que les gens décident de rentrer au Canada par des moyens encore plus dangereux. Ils vont quand même rentrer.
Premièrement, l'organisation est très importante et j'ai beaucoup de respect pour Amnesty International, mais je ne suis pas en accord dans cette instance. C'est important de reconnaître les États-Unis à l'habilité pour les personnes qui arrivent aux États-Unis à l'habilité pour faire une demande d'asile. Le système n'est pas exactement la même chose au Canada, mais le système dans les États-Unis, ça marche. Maintenant, j'ai l'habilité chaque année pour considérer des habilités pour la personne qui fait une demande d'asile aux États-Unis. Et maintenant, les États-Unis satisfient les obligations pour être un pays sûr. C'est important de continuer de conduire des exercices pour considérer le statut des États-Unis et des autres pays avec une entente similaire. Maintenant, c'est juste les États-Unis, mais c'est essentiel pour le Canada de continuer de coopérer avec les États-Unis et augmenter la capacité pour les pays dans l'hémisphère par collaborer avec nos partenaires dans la région et pour faire des investissements dans des organisations sociales pour promouvoir les droits des demandeurs d'asile. Ce n'est pas un enjeu facile ou simple, mais aujourd'hui, le Cour a reconnu l'habilité pour le gouvernement de renforcer les frontières et accueillir des personnes plus vulnérables en même temps.
The court, I believe, found that there was some concerns that there could be gender-based discrimination for folks who were sent back to the United States. Does the government of Canada see it as an issue, and will you do anything about it, please?
Look, I can tell you this is something I personally think on routinely. There's a number of different complex scenarios that can arise in the facts of a given case, and it's very important that we don't classify them all to be similar in kind. The claims, the situations are not monolithic in nature. The facts of an individual case can vary widely. And I think for that reason, discretionary remedies that exist, as to use the court's language, through safety valves is very important. My view is that to the extent that a person can make an asylum claim in the country in which they are first safe, that is where they ought to. That promotes orderly migration. There are going to be areas, including gender-based violence, where we need to initially have a case-by-case approach. But to the extent that we can work with civil society organization, with affected persons, with their advocates in the months and years ahead, where it makes sense and we're dealing with a population who does not have the ability to be safe in the country where they first seek to make an asylum claim, I think those are good areas for collaboration that we may seek to identify as we continually reform the quality of these agreements. I don't want to suggest for one moment that the agreement will always and forever be in the identical form that it is today. We need to continue to adjust the realities of our agreement with our partners to reflect the realities that people experience on the ground, including when it comes to gender-based violence.
Are you prepared to instruct the border guards to say when it's a gender-based claim that is not one that's recognized in the U.S., that's barred from a claim, that they should allow those people to make their claims in Canada? Are you prepared to say that?
In a blanketed way, I don't think it's appropriate that we treat all claims identical by saying everybody who meets a certain kind of persecution or threat of violence is going to be treated identically. There are different kinds of persecution or violence a person may face that may enable them to receive protection without actually making an asylum claim. This is an issue that comes up, but to use the legalistic language, it's usually referred to as internal flight alternatives, where there's a person who has the ability to be safe in another part of the country in which they find themselves. They usually don't have the ability to make an asylum claim, and it doesn't trigger the responsibility of other states to allow them to make an asylum claim. Where we're dealing with an individual who truly is not safe in the country in which they find themselves and does not, under the existing version of the agreement, have the ability to make an asylum claim in Canada, I would expect that those are the kinds of scenarios where an officer would use the safety valve. However, the facts of an individual case will dictate whether that would be an appropriate remedy in those circumstances. We don't simply want to open the asylum process for anyone who faces violence when in fact they could be safe somewhere else in the country in which they're currently situated, but to the extent a person truly cannot be safe and cannot make an asylum claim under the existing agreement, those are the kinds of public interest exemptions that exist under the agreement that I would expect the officers to consider using their discretion, but it's heavily fact dependent.
Do you have data on about how many times these safety valves have actually been used, especially since the Safe Third Country Agreement was expanded to include the entire border?
If you want to follow up with more specific questions, we'd be happy to provide what information we do. But just one point that I'd like to make just to identify why we might not have front of mind perfect data that I can share with you off the top of my head is the exemptions have applied for people who make claims at points of entry as well as between points of entry. So the exact change that may come as a result of the recent change in posture as a result of the additional protocol to the Safe Third Country Agreement is a little bit unclear if you're asking for people who previously came in between points of entry, because if you came in on the basis of having family here, we saw a significant number of people who previously crossed between points of entry use an irregular pathway despite the fact they could have gone to a point of entry. So if you want to provide a little bit of clarity after we leave today, we'll follow up with whatever information we have available.
How confident are you that the Safe Third Country Agreement would pass the test of a challenge for Article 15 of the Charter, which is not the same?
Yeah, so it's important, and just for the benefit of the viewers, I expect you're very familiar with this already. The court's decision today denied the challenge that was based on Section 7, which engages principles of fundamental justice, some of the most serious...
They denied on 15.
No.
They accepted on 7 and said 15 has to go back to the lower courts.
No, I think we're just based on the perspective that we're using. They've denied the claim that was made on the basis of Section 7 and recognized the government's ability to uphold the agreement despite that argument. They did not make a decision on the Section 15 argument because the lower courts had not made a decision that was gone through the appropriate appeals process. When we designed the agreement that we negotiated with the United States, the legal obligations of the Government of Canada were front of mind. We have no interest in moving forward with a plan that's going to erode or violate the charter protections that we care about dearly, that we defend in the chamber behind me every day. We design programs that are purposefully constructed to respect Canadian law, including the Constitution, including the Canadian Charter of Rights and Freedoms. So we remain confident that the agreement is constitutionally valid to the extent the federal court has guidance on how it may be improved. Of course, as an officer of the court, being a lawyer before I joined politics, this is something I would obviously respect, and we would engage in whatever conversations are necessary to respect decisions of the court that bind the government.
Last question. When will we have the details on the new people coming up as per the new agreement, the new protocol? You announced several thousand people more. When will we know the details, where they're from and so on?
Yes, as part of our negotiations with the United States, we've made an agreement to welcome an additional 15,000 people from the affected region who are at risk of displacement. We're still designing the specifics of that program. We do expect them to arrive after the 12 months following the conclusion of that agreement. So we're getting close to some final policy choices. I don't have a specific date for an announcement. There is a little bit of work that needs to be completed. I do anticipate as soon as Friday of next week that I may be in D.C. be meeting with my counterparts in the United States to follow up on the work that we're doing, not only to build out the program for 15,000 people from the region, but also to discuss what investments we may make to build capacity in the region with state partners and civil society organizations. I expect it'll be over the course of this summer. Certainly, I expect we'll have news, hopefully sooner in the summer than later, but I don't have a specific date, and as soon as we have final policy decisions that have been taken, of course, we'll be sharing them publicly. OK, merci tout le monde, j'apprécie. Et j'apprécie votre patience avec ma français. C'est difficile pour moi.
Je sais que vous essayez, c'est juste ça qui compte.
OK, je vais continuer mes efforts.
Oui, on lâche pas, on continue.